If you have never dealt with a federal agency in a regulatory capacity, you may not fully appreciate the specific quality of silence that falls over a room when a federal citation is placed on a table. It is not the silence of a conversation pausing. It is not the silence of someone thinking about what to say next. It is the silence of a person who has, in the course of pursuing what they were certain was a minor local dispute about gravel on a road, suddenly found themselves in the presence of an authority so far above the scale of what they were operating on that their entire framework for understanding the situation has to be reconstructed from the ground up. It is, in my experience, one of the more clarifying silences a person can experience, and the woman who experienced it on a Thursday afternoon in October, sitting across a conference table from a Department of Transportation regional compliance officer, was experiencing it with the full intensity of someone who had never in her years of HOA authority expected that authority to have a ceiling, let alone a ceiling this specific and this federal. Her name was Gloria Marsh. She had been the HOA president of Ridgecrest Estates for 6 years. She had spent those 6 years operating with the particular confidence of someone who has found an arena in which they are unchallenged, and the confidence had become, over time, a form of operational blindness, an inability to perceive the existence of constraints on her authority because the constraints had never materialized before. She had amended guidelines, issued fines, commissioned work on common areas, and managed the community's affairs with an absolute thoroughness that most of her fellow residents had found either admirable or exhausting depending on their disposition. And she had done all of this without anyone or anything pushing back in a way that required her to recalibrate. She was, by every measure available within her operational context, completely in charge. She had not been operating in a context that included federal transportation infrastructure until she decided to dump 3 truckloads of crushed limestone gravel on my private access road. That decision introduced her to a context she had not anticipated and was not equipped for, and the introduction was made by a DOT compliance officer named Robert Chen, who had a binder of documentation and a tone of absolute professional calm that was considerably more frightening in the room than any amount of raised voices would have been. But I need to give you the full picture of my road and why it mattered before I give you the dot. My name is Alan Whitford. I am 57 years old. I am a civil engineer, retired from 30 years in infrastructure and transportation project work, the last 14 of them as a senior project engineer specializing in road design and surface transportation systems. I know roads. I know how they are built, how they are classified, how they interact with state and federal transportation networks, what the regulatory framework is at every level of government that touches a given road, and what the specific legal consequences are of interfering with transportation infrastructure at any of those levels. This professional background was not something I had ever expected to deploy in the context of a neighborhood dispute with an HOA president. It turned out to be exactly the background needed. I live on a property at the eastern edge of Ridgecrest Estates. My property is a 5-acre parcel that I bought 11 years ago after I retired, planning to build a permanent home on it and to use the land for the small-scale farming operation my wife Carol had been wanting to establish. The parcel is not part of the Ridgecrest Estates development in a platted sense. It is a separate parcel that abuts the eastern boundary of the development and that I access via a private road. The private road is the thing this story is about, so I want to describe it precisely. The road is a single-lane paved access road, approximately a quarter-mile long, that runs from the county highway at its western end to my property at its eastern end. It passes through what is technically the eastern edge of the Ridgecrest Estates development, crossing 2 corners of community property before reaching my property boundary. The road was established as a private access easement in the original subdivision plat of Ridgecrest Estates, recorded with the county 18 years ago, long before I bought my property. The easement granted the owner of my parcel permanent access rights across the community property, with the road's surface maintenance to be shared proportionally between the parcel owner and the HOA. When I bought the property, I inherited the easement and the maintenance obligation and had been maintaining my proportional share of the road faithfully for 11 years. The road also had a federal dimension that the easement document mentioned in a footnote, but that most people who had read the easement over the years had apparently treated as a routine legal formality rather than an operative fact. The footnote said that the access road intersected with a right-of-way corridor designated in the Federal Highway Administration's National Transportation Network as a secondary connector route. The designation was legacy infrastructure from a period when the corridor had been considered as a potential future route expansion. And while the expansion had never happened and was no longer actively planned, the designation had never been formally removed. This meant that the road, or more precisely the right-of-way corridor in which the road sat, was technically within the purview of federal transportation infrastructure regulations, specifically the regulations governing access, modification, and obstruction of federally designated right-of-way corridors. I knew about this federal designation because I had read the easement document and the title chain thoroughly when I bought the property, and because I was a transportation engineer, and I knew what that footnote meant, and I had verified it with the FHWA's regional office when I first moved in. The FHWA contact had confirmed the designation was still active in their records and had noted, with the slightly rueful tone of a bureaucrat managing legacy classifications, that it was one of several thousand such designations that had never been cleaned up from the planning era that had generated them. He said it was functionally dormant, but legally extant, and that anything materially affecting the right-of-way corridor would technically fall under their jurisdiction. I had filed that information in my professional memory and had not expected to need it. Gloria Marsh had not read the easement footnote, or if she had read it, she had not understood what it meant. Or she had understood what it meant and had decided, with the operational confidence that 6 years of unchallenged authority produces, that a dormant federal designation was not something that was going to interfere with her decision to resurface a section of the community's road network. The resurfacing project was Gloria's. She had decided in the late summer that the Eastern Community Road section, which included the shared portion of my access road, needed surface improvement and had commissioned a contractor to apply a gravel surface treatment to improve drainage and reduce dust. This was, as a general matter of road maintenance philosophy, a reasonable enough goal. Gravel surface treatments are a standard approach to certain kinds of secondary road conditions. The execution, however, had a problem. The problem was that my access road was not a gravel road. It was a paved road. It had been paved since the original construction of the development, and I had been maintaining the paved surface of my proportional section for 11 years. Applying a gravel surface to a paved road does not improve the road. It covers the existing surface with loose material that reduces traction, increases wheel spray, creates drainage complications, and degrades the structural performance of the underlying pavement by trapping moisture against it. Applying gravel to a paved road is not a surface improvement. It is a surface degradation that costs money and labor and produces a worse road. I knew this as a civil engineer with 30 years of road infrastructure experience. I also knew it, at a more immediate level, as the person who drove on that road daily and who was going to have to deal with whatever condition resulted from the treatment. The contractor applied the treatment on a Wednesday while I was in town. I came home Wednesday afternoon to find 3 truckloads of crushed limestone gravel distributed across the surface of my access road. Not the full length of the road, just the section that crossed community property. Approximately a third of the road's total length. But that third included the section closest to the county highway junction, which was the section with the highest drainage sensitivity, and the section where my vehicle's speed was typically highest as I accelerated from the highway junction. I stopped my truck at the edge of the gravel section and looked at what had been done to my road. The gravel was about 2 inches deep in most places, deeper in the low spots where it had collected. The underlying pavement was completely covered. The road looked, to a casual observer, like a gravel road that had always been a gravel road. To me, it looked like 2 inches of drainage compromising, traction reducing, pavement damaging loose aggregate sitting on top of a perfectly serviceable paved surface that had just been treated as if it were a dirt road in need of stabilization. I drove through it slowly, feeling the loose stone under my tires, and I noted, without yet acting on the notation, the specific federal implication of what had been done to the corridor. I went inside and called my attorney, Patricia Chow, who had handled my property purchase and was familiar with the easement and its terms. I described what had happened. Patricia said the modification of the road surface without my agreement violated the easement's maintenance provisions, which required that any material change to the road surface be agreed upon by both parties to the maintenance obligation. She said she would send a formal demand letter requiring the gravel's removal and restoration of the road surface. She also asked if there were any other relevant considerations she should be aware of. I said yes and described the federal designation. Patricia was quiet for a moment. She asked me to send her the documentation on the FHWA designation. I did. She reviewed it and called me back the following morning. She said she wanted to discuss the federal dimension carefully before doing anything with it, because it was a significant escalation and she wanted to make sure we were using it correctly. I said I agreed that it needed to be used correctly and that I had a specific approach in mind. My approach was not to use the federal designation as a threat or as a negotiating chip. My approach was to report it. The FHWA's regulations required that any modification to a federally designated right-of-way corridor be reported to the regional office, and that the modification comply with applicable access and surface standards, and that non-compliant modifications be corrected. This was not a rule I was going to cite to Gloria as leverage. It was a rule that I was going to comply with by doing exactly what the regulation required, which was notifying the relevant agency of a modification to federally designated infrastructure. I called the FHWA regional office and spoke to the compliance division. I described the modification, the application of loose gravel to a paved surface within the designated right-of-way corridor, and provided the corridor designation number from the footnote. The compliance officer who took the call looked up the designation and confirmed it was active. He confirmed that the modification I had described was a non-compliant alteration of the corridor's surface condition under the applicable regulations. He said the office would open a compliance review and that I would be contacted with further information. I also called the state DOT because the access road interacted with the county highway at its western end, and the county highway was on the state road network. The state DOT's interaction with the corridor was secondary to the federal designation, but was an additional regulatory layer that the gravel modification implicated. The state DOT's Access Management Unit confirmed that any modification to road surfaces connecting to the state highway network that materially altered drainage characteristics or surface conditions required notification and review. Patricia sent the formal demand letter to Gloria, and the HOA board the same day I made the calls. The letter described the easement violation, the requirement that the gravel be removed and the road surface restored, and noted that the modification also implicated federal and state transportation regulations that were being reviewed by the relevant agencies. Gloria's response to Patricia's letter arrived 4 days later. It was on HOA letterhead, and it was, in its tone, consistent with the response of a person who did not take the federal and state dimensions seriously. It said the HOA had made a good-faith surface improvement to the community road, and that the improvement was within the HOA's authority to maintain community road surfaces, and that the demand for removal was unwarranted. I noted the specific characterization, a good-faith surface improvement, and filed it. Patricia responded stating that the modification was not within the HOA's authority because it violated the easement's bilateral maintenance requirement, and that the federal and state regulatory reviews were proceeding, and that compliance with the demand letter would reduce, but not eliminate, the regulatory exposure the HOA had created. Gloria did not respond to the second letter. The FHWA compliance review moved at the pace of federal agency processes, which is not fast, but which is thorough and which produces, when it concludes, documentation that has a weight and an authority that is difficult to dispute. The review officer assigned to the matter was Robert Chen, and he called me approximately 3 weeks after I had filed the initial report to discuss the situation in detail. Robert Chen was a precise, methodical man who had been in the FHWA compliance division for 16 years and who had the particular professional quality of someone who has spent a long time doing detailed regulatory work. He was not dramatic, not adversarial, not looking for a confrontation. He was looking for compliance, and he was very clear about what compliance required and what the consequences of non-compliance were. He told me that after reviewing the designation, the corridor documentation, and the modification I had described, the FHWA had determined that the gravel application constituted a non-compliant surface modification under federal transportation regulations. He said the responsible party, the HOA, would be receiving a formal compliance notice requiring correction of the modification within 60 days. He said the compliance notice would also cite the failure to obtain required pre-modification clearance from the FHWA prior to altering the corridor surface. He said, if the HOA wished to discuss the situation directly, they could contact the compliance division, and that he was available to meet with their representatives. I asked whether the HOA had been notified yet. He said the formal notice was being prepared and would go out within a week. I asked if it was possible to arrange a meeting at which the compliance notice would be presented and discussed, rather than simply mailing it. I said I thought a face-to-face meeting with the compliance officer would be more productive than a letter, given the HOA's apparent lack of appreciation for the regulatory dimensions of the situation. Robert Chen said he was willing to attend a meeting and that the FHWA Compliance Division occasionally conducted in-person compliance conferences when the situation warranted it. He said he would contact the HOA to propose a meeting. He contacted Gloria and proposed a meeting for the following Thursday at the county's Public Works Conference Room. Gloria agreed to the meeting without, apparently, being told the specific nature of what Robert Chen would be presenting, because when she arrived at that meeting, she arrived with the posture and manner of a person who expected to explain her position and resolve a misunderstanding rather than a person who expected to receive a federal compliance notice from a federal agency official. She was accompanied by the HOA's attorney, a man named Douglas, who I had encountered previously in the easement correspondence. Douglas, at least, appeared to have some sense of what the meeting might involve. He had a legal pad and a cautious expression when they sat down across the table from Robert Chen and me and Patricia. Robert Chen opened the meeting by placing a copy of the FHWA compliance notice on the table in front of Gloria. That was when the silence happened. The compliance notice was 11 pages. Robert Chen gave Gloria and Douglas time to review the first 3 pages. The summary section, which described the violation, cited the regulatory provisions, and stated the required corrective action and timeline before he began speaking. Those 3 pages took approximately 4 minutes to read. During those 4 minutes, the room was quiet in the way I described at the beginning of this story. Gloria read, Douglas read faster and made notes. Patricia and I sat on the other side of the table and waited. When Robert Chen began speaking, he did so in the same way he had spoken on the phone, precisely, methodically, without drama. He explained the federal designation's history and current active status. He explained the regulatory provisions that governed modifications to designated right-of-way corridors. He explained what a non-compliant modification was and how the gravel application met the definition. He explained what the compliance notice required: removal of the non-compliant surface material and restoration of the corridor's pre-modification condition within 60 days, documentation of the restoration provided to the FHWA, and submission of a pre-modification clearance application for any future planned modifications to the corridor surface. He also explained the consequences of non-compliance. Federal transportation regulations provided for civil penalties for unresolved non-compliant modifications to designated corridor infrastructure. The penalty structure was tiered: initial notice, follow-up notice with increased penalty, and referral to the Department of Justice for enforcement if the violation remained unresolved. The civil penalties for unresolved violations in the relevant category were, Robert Chen explained in the same calm tone he had used throughout, assessed per day from the expiration of the compliance window. The daily rate for an unresolved modification of this type was a figure that I will not state specifically, except to say that it was high enough that 60 days of non-compliance would produce a penalty that exceeded the HOA's annual operating budget. Douglas wrote something on his legal pad and underlined it. Gloria said that the HOA had conducted the surface treatment as a community maintenance activity and had not known it was a federal violation. Robert Chen said he understood and that the compliance notice did not address intent. It addressed the modification and its status under applicable regulations and the steps required to bring the situation into compliance. He said the good news was that the corrective action was straightforward: removal of the gravel and restoration of the paved surface, and that if completed within the 60-day window, the penalty structure would not be activated. Gloria asked whether the federal designation could be removed or modified. Robert Chen said that the designation was a matter of the FHWA's classification records, and that there was a process for requesting reclassification of legacy designations, which was a multi-year administrative process that did not affect the current compliance obligation. Douglas asked whether there were any circumstances under which the compliance window could be extended. Robert Chen said extensions were available under certain conditions, and that a request for extension needed to be submitted in writing within 30 days of the notice date and needed to demonstrate active progress toward compliance. Douglas made another note. I want to describe what Gloria looked like during this meeting, not with any satisfaction, but because it is relevant to understanding what happened afterward. She had arrived at the meeting with the posture and the manner of a person who was going to manage a situation. She was going to explain herself, make her case, invoke her authority, and produce a resolution consistent with her position. This was how she had operated for 6 years, and it had always worked, because the people and institutions she had operated against had always been within her operational context: homeowners, contractors, local officials who had some connection to the community and who were therefore manageable. Robert Chen was not in her operational context. He was from an entirely different level of government with a completely independent mandate and no relationship to the Ridgecrest Estates community whatsoever. Her authority as HOA president was completely invisible to him. His authority was backed by federal statute and a penalty structure that operated with the indifference of federal regulatory machinery to the scale of the entity it was applied to. The HOA was not too small to receive federal penalties. The HOA was the responsible party under the regulations. That was the full extent of what was relevant to Robert Chen. Gloria's posture changed during the meeting. Not dramatically, she was not the kind of person who made dramatic physical expressions of her emotional state. But the composed management energy she had brought in the door gradually became something quieter and more careful. By the time Robert Chen finished his explanation and asked if there were any questions she had not yet asked, she looked like someone who had done the calculation and understood the answer. She had one more question. She asked whether the FHWA's jurisdiction in this matter superseded the HOA's authority over the community road section. Robert Chen said, with the precise neutrality of a federal official stating a legal fact, that federal transportation regulations superseded local governing authority with respect to designated federal corridor infrastructure. He said the HOA's authority to manage community roads was not in question generally, but that within the designated corridor, the federal regulations were the controlling framework. Gloria did not ask any further questions. The meeting ended. Robert Chen shook hands with everyone, gathered his materials, and left in the way that federal officials leave meetings without ceremony or drama, moving on to the next item on a schedule that had many items. Douglas and Gloria spoke briefly in the hallway outside the conference room. I could not hear what they said, but the conversation was short, and when it ended, Gloria walked to her car without looking in the direction of where Patricia and I were standing. Patricia said we should give it a week and see what the HOA's response looked like. The HOA's response came in 4 days. Douglas sent Patricia a letter proposing a comprehensive resolution. The HOA would remove the gravel from the road surface at the HOA's expense. They would engage a qualified road surface contractor to restore the paved surface to its pre-modification condition, also at HOA expense. They would provide all documentation to the FHWA as required by the compliance notice. They would submit to Patricia a written acknowledgement that the modification had been made without proper consultation with me as the easement co-holder, which was the easement violation separate from the federal issue. And they would, as part of the resolution, agree to a joint road maintenance protocol for the shared road section, a written protocol that would require both parties to agree in writing before any surface treatment, material application, or other modification was made to the road. Patricia reviewed the letter and called me. She said the terms were comprehensive and addressed all of the substantive issues. She said her only suggested modification was that the joint protocol should include a specific provision requiring the HOA to obtain FHWA pre-modification clearance, as Robert Chen had specified, before any future road work. Douglas accepted the modification. The resolution agreement was executed 3 weeks after the meeting. The gravel removal happened the following week. I watched the contractor's crew sweep and vacuum the limestone off the paved surface, which was more labor-intensive than putting it there had been, and then apply a light resurfacing treatment to address minor surface damage from the gravel application. The paved surface was restored to better than its pre-modification condition. The HOA submitted all documentation to the FHWA within the compliance window. Robert Chen confirmed receipt and closed the compliance file. I received a copy of the closed compliance file from Robert Chen's office as a courtesy. I filed it in the property documentation folder with the survey records and the easement and the title chain and all the other documentation that accumulates when you own land with a legal history and you pay attention to it. The Joint Road Maintenance Protocol has been in effect for 2 years. In those 2 years, there have been 2 road maintenance conversations between me and the current HOA's Facilities Committee, both conducted professionally, both resulting in documented agreement before any work was done, both producing road treatments that were appropriate for the surface type and the corridor conditions. The road is in the best condition it has been in since I moved to the property. Gloria Marsh did not run for re-election as HOA president when her term ended 8 months after the meeting with Robert Chen. She made no public statement about her decision. The community elected a new president named Patrick, who had been on the board for 3 years and who had, based on what I heard from neighbors, found the federal compliance situation a clarifying experience about the limits of HOA authority in the context of larger regulatory frameworks. Patrick ran the HOA with what I would describe as a newly calibrated understanding of what HOAs are and what they are not, which is to say, community governance organizations with authority within their domain and no authority whatsoever outside it. Robert Chen's quiet, methodical, completely calm explanation of the federal penalty structure had apparently communicated something that no amount of letters or demands or legal proceedings could have communicated as efficiently, which was that some rules are bigger than any local organization's conviction that they are in charge. I have thought about why the meeting worked the way it did, and I think the answer is something about scale. Gloria Marsh had spent 6 years as the largest authority in a small operational context, and the operational context had never given her reason to understand that there were larger authorities outside it. The HOA was her universe, and in her universe, she was in charge. Robert Chen represented something that existed completely outside her universe, and that did not care about the HOA or its governance history or her 6 years of authority or anything. except whether a piece of federal transportation corridor infrastructure was compliant with federal regulations. The collision between her universe and his was a collision between a very large fish in a small pond and a piece of the ocean, and it had the effect that that collision always has. The fish becomes suddenly aware of how small the pond was. The road is fine. The corridor designation is still active. As Robert Chen had noted, the reclassification process is multi-year, and I have not initiated it, partly because the dormant designation turned out to be useful when I needed it, and partly because there is something appropriate about the road having that particular layer of protection given its history. Anyone who decides to modify it in the future without proper consultation will find the same footnote I found 11 years ago and will, if they are wise, call the number it references before they order 3 trucks of limestone gravel. Carol's farming operation is fully established now. The road handles the daily traffic of a working small farm, supply deliveries, equipment movements, the occasional larger load during harvest season. It handles this traffic well because it is a properly maintained paved road on a properly established corridor, and because the people responsible for maintaining it now do so with a shared protocol and a mutual understanding that neither party acts alone on the shared surface. That understanding was always what the easement intended. It just took a federal compliance notice and a very quiet room to make it actual. Thumbnail text. Line 1, HOA Karen dumped gravel on my private paved road without asking. She had no idea it was on a federal highway corridor face with steam from nose. Line 2, when the DOT compliance officer placed 11 pages of federal violations on the table, she went completely silent. Classical building construction.